And this question came through earlier today about how do I keep track of important deadlines as I move through the patent process? Hi, I'm JD Houvener, patent attorney, owner here at Bold Patents Law Firm. I've been helping inventors now for over 10 years, helping them achieve almost 500 patents as of today. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. And that book is available on Amazon.com. And for you and you listeners here on YouTube, it's available here at the link below. It's the Bold Inventors Kit. You get a PDF download as well as a lot of cool tutorials on patent searching and patent prosecution, as well as the patent prosecution matrix. So take a look at that. Click the link below. Give us a like, thumbs up, and subscribe to our channel too for more information on your daily Monday through Friday video from yours truly. This question is good about how do I keep track of timelines as I move forward through the patent process. Now, timelines regarding deadlines, when the USPTO requires you to submit a response or when you must submit based on a timing statutory bar. Okay, let's start with the really, really big ones. And I emphasized this in an earlier video last week for those that are following along on my program. Statutory bars are when you have a 1 year drop dead date of when you have to file a patent application. This is when you've had a public disclosure or an offer for sale or even selling your product. For any time more than a year, it's ineligible and it will be invalidated at the USPTO. So if you're within that time period, make sure you get your filing in. Even if it's a provisional patent application, submit that well before the 1 year mark of when you initially sold it, published it, or offered it for sale. So that's the biggie. Once you file your patent application, then you've got some new timelines. Especially if it was a provisional patent application, you have exactly 365 days, 1 year, to file a non-provisional that makes priority back, claiming that priority from the early provisional filing date. That is a very cut and dry 1 year rule. Make sure you give yourself plenty of time to draft the non-provisional. So I used to say, usually talk with clients about 9 months. If you're going to wait that full year and use that time to its maximum, start around the 9 month mark, giving yourself 2-3 months max to prepare all the drawings, prepare the specification, the formal, the rigor of the application, the IDS, the claims, everything that's involved in the spec and the detailed drawings. So everything is all bundled and prepared by that 12-month deadline. Once you submit the non-provisional, that's when you can start getting serious notices from the patent office. Usually if there's a missing parts or if there's a, call it a formality error with your application submittal, you'll get a notice of missing parts, a notice that your failure to pay the fee. Lots of different things can come up from an administrative level where it's not being evaluated on the merits. I mean, the examiner has not done a search. They have not done evaluation of the prior art or examined the application yet. These are more about the formalities of the actual paperwork, the forms that are submitted. They will give deadlines, and you've got to be very careful not to be late, or your application will go abandoned. Abandonment is the state where you no longer have the ability to file arguments, to move forward with your application. It is stuck. You have failed to respond or pay fees that are required through the prosecution. There are ways to revive an abandoned application. You've got a petition. You have to pay additional fees, file more documents, and explain what happened. Usually the typical responses are the financial hardship, or perhaps there was a communication error you can demonstrate. You didn't actually receive the notices that you were late or the deadline was coming up. So make sure you're ahead of the game because those additional petitions and fees are not guaranteed to be successful, and they require additional work just to get the application out of that state of abandonment. Now, some typical things that we have put in place as attorneys for our clients are docketing software, right? We have hundreds of applications, lots of inventors. We need to make sure that each of these dates are hit. So we use docketing software that will help us remember these deadlines well in advance of their actual coming. On top of that, we use a secondary calendar system in case that first line fails, including calendar, online calendar using Google, as well as personal reminders that pop up on our task list. So really, it's a threefold approach to making sure that your information is valuable and we don't miss the deadline, so we don't end up in a state where we're struggling and behind and need to petition to the patent office. Well, hope it was helpful. I know it's kind of that, what you expected to hear, but stay on top of your dates. Don't let your application go abandoned. Make sure you're responding timely. All right, everybody, have a good rest of your day. Go big, go bold.